Did it do?
Okay.
Sorry, can you hear me?
Yes, I can.
Okay. So I decided that I already filed everything that needed to be filed. I don't know. I can't remember if first of all, I want to apologize because I wasn't feeling very well last time I was in court.
You are fine.
That's the first thing I want to say.
You are fine. You sound like you still might be a little bit sick, so.
A little bit, but I'm getting better. That's all
Okay.
that matters. I'm getting my voice back.
Good.
But I wanted to say that I already filed everything that I was supposed to, but I can't remember if I filed a roommate release. Matthew Posner actually moved out last year,
Okay.
and I took full responsibility of everything. So I did want to say that on record.
Okay.
And then I also filed a quick deed claim, and that's actually in Cowlitz County Auditor's Office already. And Elazar signed that. And he also did a warranty deed.
And
so I'm not exactly sure.
what was the date that was filed with the auditor?
I have getting older. Let me put these fancy bad boys on. 4/29. And the reason being is because I didn't have the money to file the paperwork.
Okay.
I am a single mom, and it's just Marley and I.
Did Ms. Radecki, did you receive that?
So, Your Honor, I received some deed from her. I don't recall if that was the date. I can check my inbox though, but there was nothing to do with her name to the best of my recollection on it, nor Mr. Jackson's
Okay.
interest conveyed to Miss Kanata.
Okay. So it sounds like we're ready to move forward then. So Ms. Radecki, this is your motion, so I'll turn it over to you. And then Ms. Quinata, you will have the option and ability to respond.
Sure.
Okay, go ahead, Ms. Radecki.
Thank you, Your Honors. Plaintiff is Annette Jackson. We're seeking a preliminary injunction and a writ of ejectment today, so that my client can get her home back. In Washington, courts that assess a three-part test generally when trying to assess whether a preliminary injunction is appropriate. Those three prongs does the person have clear right to possession? Is there a well-grounded fear or invasion of that right? And then the third one is is there continued injury resulting from defendant's unlawful occupancy? So ultimately, the relief that we are requesting today is immediate removal of defendants and any unauthorized occupants, an order prohibiting the defendants from taking, damaging, moving, or selling any of plaintiff's property, restoration of any personal property that's already been taken or damaged.
All right, folks, welcome to the beginning of what I can only describe as Karen Court Week, and trust me, we are starting strong. This case has everything: a squatter, a divorce, fake paperwork, sovereign citizen logic, and a woman who genuinely believes that filing random documents magically makes her a homeowner. What you're about to see is a masterclass in soft-spoken confidence paired with absolute legal delusion. She's calm, polite, even sounds reasonable at first, and that's what makes this dangerous. Because beneath the calm voice is the same recycled pseudo-legal nonsense we've seen destroy people's lives again and again. Fake deeds, fake authority, and a refusal to accept reality. Stick around, because by the end of this hearing, the court is going to dismantle her entire fantasy, and yes, homelessness is very much on the table.
Sole legal owner of the premises, pursuant to a final divorce decree entered on August 26, 2024 in Cowlitz County. The cause number was 232-002-4408. That was attached as Exhibit D to our complaint. Defendants have never had a valid lease agreement, never had paid rent or a legal right to reside on the premises. The defendants had submitted a lease agreement. They purported it was valid, but it was not issued by Ms. Jackson, the plaintiff. It was not signed by her. Ultimately, they are not tenants. The defendants entered the premises without plaintiff's knowledge or consent after she was forced to leave the home due to domestic violence. RCW 7.28 supports plaintiff's legal right to possession as the record and sole title holder and the only legal owner to the property. Defendants don't assert any valid ownership rights or tenancy. They were at best holdover licensees, but now have been trespassers since they were served with the proper notice to vacate back in February of 2025. So moving on to the well, the next factor, the well-founded fear of immediate invasion of the rights. Defendants remain in unlawful possession and continue inviting strangers onto the property. Law enforcement frequently visits the property. Plaintiff had visited the home in December of 2024 with law enforcement and discovered a number of concerning things, but especially highlighting missing personal property. Her dogs were locked inside the house without food or water, and there was just general disrepair and suspicious activity occurring inside the home. The continued occupation of the defendants prevents plaintiff from accessing, maintaining, or safeguarding her property, and has violated her rights as a property owner. So moving on to the third and final factor regarding the actual and substantial injury to the plaintiff. There has been ongoing economic and personal harm that the plaintiff, Ms. Jackson, has suffered from the inability to reside in her home. She's had to incur additional financial expenses to house herself elsewhere in the interim. Property has been missing and gone damaged inside her home, the property that's subject of the action. She does have concerns about the well-being and welfare of her animals and other personal property that she's not been able to observe in the past 6 months. And this has caused her a great deal of emotional distress, and she has safety concerns about the property and welfare of everything there. Defendant's presence is causing continued deterioration and damages, and plaintiff is concerned about further damages if the preliminary injunction is not granted today. At this point, these injuries, a lot of them are irreparable and not compensable solely with monetary damages. So regarding the balance of equities, just to touch on that for the court, the courts may weigh hardship when considering a preliminary injunction, but only for innocent parties generally. The defendants were warned of their status as trespassers and received a 3-day notice to quit on or about February 8th of 2025, but failed to vacate and clearly still occupied the premises. They knowingly remain without rights to do so, and Ms. Jackson is entitled to recover her property back and eject the defendant immediately without further delay. Plaintiff's hardship, loss of access to the property, damage to personal possessions, possibly her animals, and an inability to exercise ownership rights far outweighs any minimal inconvenience to the defendants at this point. They've had well over 3 months of notice to vacate and have still failed.
This right here is your first major red flag. The judge asks a straightforward question about legal counsel, and instead of answering directly, she pivots to vague statements like, "I already did everything I needed to do." That's not an answer, that's avoidance. Judges ask about counsel because they're making sure you understand the seriousness of what's happening. And when someone shrugs that off, it tells the court they either don't understand the stakes, or they think they've outsmarted the system. And in these sovereign-adjacent cases, it's usually the second one. Watch how she presents herself: calm, apologetic, cooperative. This isn't accidental. It's a strategy, appear reasonable while quietly asserting imaginary rights in the background.
Typically, adverse possession does require quite a lengthy period of open, notorious, hostile use. So if you want to start there, feel free. Go ahead.
Okay. First thing I want to say with the adverse possession, I've had to fix the furnace. I've had to fix everything on the maintenance side of that. I already mentioned that Matthew's not there. It's just me and my son. And I kind of took some notes a little bit, but I've been there for almost 3 years, going on 3 years. I don't know how long she's lived there. When Eleazar left, and I'm not part of their divorce case, so whatever property she had went with Eleazar, and whatever property she had went with her. So I don't have any of her property. The other thing is, ADT will verify that they never came and served me. And so I actually put up ADT systems because there were people that were coming to the house, and it was just Marley and I. And so I do have that. And then I also have that I was reaching out to her, and I posted notices, hey, what's going on? And that's verifiable through Woodland Police Department, because they had taken some reports and had said, we've seen a notice on the door, and they actually verified that there wasn't public notice on the door, and on the street side, so that she could see, hey, this is what I'm doing. Where do I pay my rent? What do I do? So I started that, I think in September, after or whenever their divorce was, I started reaching out to her, and all I got was, well, I talked to, I always forget his name, the mayor of Woodland. Anyways, I was talking with him, and I said, is there a reason why all this is going on? And he said, well, she still owns the house. I go, I know, but I'm just trying to communicate with them. So he knows about the situation too. And then I also spoke with my son's advocate through missing and exploited children. I've been talking with her about it because Annette had installed cameras at the house, and that's why we ended up getting ADT. So I do have everything that is verifiable through Woodland Police Department, the mayor of Woodland, and through ADT, that I was never been served. I've never even received a notice saying, hey, new ownership. I've never received any of that. The only thing I received was an ejection. I was like, what is an ejection? I've never heard of it. So I had to do a little bit of research, and I understand what it is, but I'm not a squatter. I'm actually on a lease. I signed it with Elazar. And I'm kind of glad I did, because that's how it started, was, that we were roommates, and then it went into this whole big thing, and I've been dragged into their divorce for no reason. I mean, I get and I understand, but I'm not part of that case. The case like today is just about the house. I'm on a lease. There was an adverse possession because I kept trying to reach out to her and put posting notices, and I didn't know how to contact her. Then after that, what else was going on? Basically, that's pretty much it. I mean, and then I said, and then oh, that's right. I got a foreclosure notice on the door, and I was like, oh my gosh, what's going on? And so then I actually submitted the information to the mortgage company saying, hey, I'm right here. What can we do? And I filed and submitted a 1099A with them. And then that's when I asked Elazar. He said he didn't want anything to do with that house. I said, okay, well, will you sign? I didn't know what kind of deed to sign from him because I couldn't get a hold of Annette. And so then Elazar had signed all of them pretty much, because I put them together. I was like, I don't know.
And here it is, the paperwork dump. This is the sovereign citizen comfort blanket. If you say, quit claim, warranty deed, and county auditor enough times, surely ownership will just manifest. But listen carefully to what she doesn't say. She never explains how someone else legally transferred ownership to her. She never explains why a divorce decree wouldn't control. She just lists documents like spells from a legal grimoire. Courts don't care how confident you sound, they care who actually owns the property, and that's determined by lawful transfer, not vibes. This is where a lot of people ruin their lives, mistaking paperwork for
what they own on it. Working in this little tiny spot. So hang on. It was paid on. Of course, I got a really bad copy. I'm gonna have to pull up the original document because this is really light, the one that I submitted. But if you don't mind waiting for just a moment, I can just grab my bag and pull it out. If you'd like me to grab that and tell you the date that I paid it.
Yeah, that would be helpful.
Okay, hang on just a moment. I dropped my box right before we started this, and it was with my paperwork, but the copy that I have, the hard copy, I just can't read the copy that I made you guys.
There's a 1099 that's of poor
It's
quality.
12/24/24. Sorry, I just got it.
December of 2024.
Yes.
And did you pay the $20,000 amount, or how much?
No,
did you
I paid 487. Wait, 400. Can't even read it. $418.79. I have $79.42. And then I also paid the taxes on it, and I can grab that.
So tell me the mortgage amount that you paid in total.
$418.
This is the emotional pivot, and it's deliberate. Notice how quickly the narrative shifts from legal ownership to personal hardship. I'm a single mom. I didn't have the money. And look, hardship is real, but hardship does not create property rights. Courts can have sympathy without rewriting reality. And judges hear this constantly, people hoping their circumstances will override black and white ownership law. But emotion doesn't trump a divorce decree. And the danger here is that she clearly believes it should. That disconnect is about to collide head-on with reality, hard.
Jackson submitted to the mortgage company and clearly just a couple weeks ago to Cowlitz County, the divorce decree did not just state that Ms. Jackson was responsible for the payments. It stated that she was given the property.
Yeah.
And I'm not. Well, hold on. So she was given possession of the property, and he was mandated to leave the property. And so first and foremost, I mean, I have some concerns about what's happening behind the scenes with Mr. Jackson towards this property that he is telling state, county agencies that he has the right to this property. He does not. And you now have received through this lawsuit proof of that. You have not been in the property long enough to obtain it by adverse possession. Even if you had met all the other factors, you're not even close, frankly, timeline wise.
Right.
So there's no question in my mind that a preliminary injunction is necessary in this case. The only question for me is if a mortgage in the amount of $418,000 was.
Now the adult enters the room. This is what real legal arguments sound like, structured, calm, and devastatingly precise. No conspiracies. No rambling. Just a clean three-part test the court is required to apply. Ownership. Harm. Continued unlawful occupancy. This is why sovereign logic collapses in court, because reality shows up with receipts. While the defendant relies on vibes and paperwork she doesn't understand, the plaintiff relies on a final divorce decree, which is about as ironclad as it gets.